The fluorescent lights buzzed overhead in courtroom 302 of the Baltimore County Juvenile Court as 12-year-old Sarah Mitchell sat perfectly still, her dark brown eyes focused intently on Judge Henry Thompson. Her mother, Diana Mitchell, a high school English teacher, sat beside her, occasionally squeezing her daughter's hand for reassurance. Sarah wasn't like most 12-year-olds who entered this courtroom. While other kids might have been fidgeting or showing signs of nervousness, she maintained a calm demeanor that seemed almost out of place for someone her age. Her neat box braids were pulled back into a careful ponytail, and she wore a pressed navy blue blazer that her mother had bought from the thrift store specifically for this day. The courtroom was relatively quiet that morning, with only a few other cases scheduled. The sound of papers shuffling and whispered conversations filled the air as Sarah waited for her case to be called. What nobody in that room knew was that behind Sarah's quiet exterior lay a mind that had already memorized more legal precedents than most first-year law students. It had started when Sarah was 8 years old. While other kids were watching cartoons after school, she would spend hours at the local library, fascinated by legal documentaries and books about famous court cases. The librarian, Ms. Jenkins, had initially been surprised to see such a young child requesting books about constitutional law, but soon became used to Sarah's daily visits to the legal section. Sarah's journey to this courtroom began 3 months ago at Roosevelt Middle School. Someone had vandalized the science lab, causing thousands of dollars in damage. The security cameras had malfunctioned that day, and through a series of unfortunate circumstances, Sarah had become the primary suspect. She had been seen near the lab shortly before the vandalism was discovered, working on an independent project with her science teacher's permission. As Sarah sat in the courtroom, her mind wandered to the countless hours she'd spent preparing for this day. Her bedroom walls were covered with sticky notes containing legal terms and procedures. She had even created a mock courtroom in her basement, using old sheets as makeshift court barriers and practicing her responses with her mother playing different roles. When Judge Thompson finally called her case, Sarah stood up with perfect posture, something her grandmother had always insisted upon. The judge, a man in his 60s with salt and pepper hair and wire-rimmed glasses, looked down at her file with mild interest. What caught his attention was not the case details, but rather the numerous academic achievements listed in the background information. "Sarah Mitchell," Judge Thompson said, his voice carrying across the courtroom, "I see you're here regarding the Roosevelt Middle School incident." "Yes, Your Honor," Sarah replied clearly, her voice steady and confident. Judge Thompson leaned forward slightly, studying the young girl before him. Something about her composure made him pause. In his 30 years on the bench, he had developed a knack for reading people, especially young offenders. But Sarah Mitchell was different. "Before we proceed with the formal hearing," Judge Thompson said, tapping his fingers thoughtfully on his desk, "I'd like to try something different." He glanced around the courtroom, then back at Sarah. "How would you feel about playing a little game of truth or lie?" A few murmurs rippled through the courtroom. Judge Thompson was known for his unconventional methods, especially with juvenile cases, but this was unusual even for him. Sarah's mother shifted uncomfortably in her seat, but Sarah's expression remained unchanged. What the judge didn't realize was that in that moment, Sarah's mind was already racing through everything she knew about courtroom procedures and defendants' rights. She had read about informal questioning techniques and their legal implications. While other 12-year-olds might have been scared or confused, Sarah recognized this as an opportunity. "I'm willing to participate, Your Honor," Sarah responded, her voice clear and measured. "However, I would like to clarify if this will be considered part of my official testimony." The judge's eyebrows rose slightly at her question. The public defender assigned to Sarah's case looked up from his papers, suddenly paying more attention. Even the court clerk paused in her typing. This was the moment when everyone in courtroom 302 began to realize that they weren't dealing with an ordinary 12-year-old. Sarah Mitchell was about to show them exactly why her teachers had been calling her a legal genius, and why her IQ test results had caused such a stir at her school district's gifted program evaluation board. The game was about to begin, but it wouldn't play out the way Judge Thompson expected. Judge Thompson leaned back in his chair, intrigued by Sarah's question about official testimony. He hadn't expected such a legally precise response from someone so young. The courtroom remained quiet, waiting to see what would happen next. "Well, Miss Mitchell," the judge said, adjusting his glasses. This won't be part of your official testimony. Think of it as a preliminary discussion. He paused, watching her carefully. Are you familiar with how this game works? Sarah nodded politely. Yes, Your Honor. It's similar to a cross-examination technique used in the Robinson versus State case of 1998, where informal questioning was used to establish credibility. She spoke clearly and confidently, causing several heads to turn in surprise. The public defender, Mr. James Harris, who had been half-dozing through what he thought would be a routine juvenile case, suddenly sat up straight. He had handled hundreds of cases involving young offenders, but he had never encountered one who could cite legal precedents. Judge Thompson's interest grew even more. That's quite impressive, Miss Mitchell. You're familiar with the Robinson case? Yes, Your Honor. I found it particularly interesting because it established guidelines for informal questioning of juvenile defendants. Sarah's hands were folded neatly in front of her, her posture remaining perfect. Diana Mitchell watched her daughter with a mixture of pride and concern. She remembered the countless nights she'd found Sarah asleep with law books spread around her bed, sticky notes marking important pages. As a single mother, she had always encouraged Sarah's interests, even when they seemed unusual for a child her age. The judge began his game. I'll make statements, and you'll tell me if they're true or false. But here's the twist. You must explain your reasoning. Let's start with something simple. You were at Roosevelt Middle School on the day of the incident. True, Your Honor, Sarah responded. I was there working on an independent science project with Professor Martinez's written permission. I had the signed permission slip, which was submitted as evidence item 4B in my case file. The prosecutor, Ms. Rodriguez, quickly flipped through her papers to check this detail. Her eyebrows rose when she found the permission slip exactly where Sarah had indicated. Interesting. Judge Thompson mused. Next statement. You were alone in the science lab that afternoon. False, Your Honor, Sarah replied. While I was in the lab from 3:15 to 4:00 p.m., the janitor, Mr. Peterson, was also present, cleaning the windows. Additionally, Professor Martinez checked on my progress at approximately 3:45 p.m., as noted in his written statement. The judge leaned forward, his interest clearly piqued. You seem to have quite a detailed memory of events, Miss Mitchell. Your Honor. Sarah began, her voice steady. In the case of Williams versus the State of Maryland, 2002, it was established that detailed recollection of events can serve as compelling evidence when physical proof is lacking. Given that the security cameras were non-functional that day, I made sure to document everything carefully. The courtroom had grown completely silent. Even the usual shuffling of papers had stopped. The court reporter's fingers hovered over her keyboard as she stared at the young girl in amazement. Judge Thompson exchanged glances with the prosecutor and public defender. This was no ordinary case of teenage vandalism. The girl standing before them possessed not just a high IQ, but a remarkable understanding of legal proceedings that many law school graduates would envy. Miss Mitchell, the judge said, removing his glasses and cleaning them thoughtfully, where did you learn all this legal knowledge? Sarah's expression brightened slightly. The Baltimore County Public Library, Your Honor. Ms. Jenkins, the librarian, helped me access their legal database. I've spent approximately 1,200 hours studying various cases and procedures over the past 4 years. She paused briefly. I hope it's acceptable to mention this during our informal discussion. The judge couldn't help but smile. It's perfectly acceptable, Miss Mitchell. In fact, I think we're all very interested in hearing more about your legal studies. But first, let's continue with our game. Next statement. You know who actually vandalized the science lab? Sarah's eyes flickered briefly with recognition. This was the moment she had prepared for, knowing that her response could change everything. The truth she was about to reveal would not only clear her name but also demonstrate why assumptions about young people, especially young people of color, needed to be challenged. Sarah took a deep breath before responding to Judge Thompson's statement. The entire courtroom seemed to hold its breath, waiting for her answer. True, Your Honor, Sarah said carefully. I do know who vandalized the science lab. However, before I provide that information, I would like to cite the case of Jenkins versus Maryland State, where it was established that hearsay evidence must be supported by substantiating proof to be considered valid in court. Ms. Rodriguez, the prosecutor, dropped her pen in surprise. Even Judge Thompson couldn't hide his astonishment at hearing a 12-year-old discuss the rules of hearsay evidence. "Please proceed, Miss Mitchell," the judge encouraged, genuinely curious about what would come next. "On the day of the incident, I was in the lab working on my project about electromagnetic fields," Sarah began. "While I was focusing on my experiment, I heard voices in the storage closet. I recognized them but didn't want to interrupt my work. However, I did activate the voice recorder on my tablet, which I always use to document my scientific observations." Sarah's mother reached into her purse and pulled out a tablet in a purple protective case. She handed it to Mr. Harris, the public defender, who had finally woken up completely and was now fully engaged in the proceedings. "Your Honor," Sarah continued, "the recording captures the voices of Tyler Wilson and Marcus Green discussing their plan to damage the lab equipment because they were angry about failing their chemistry midterm. The recording also includes the sounds of equipment being knocked over and broken." The judge turned to the prosecutor. "Ms. Rodriguez, were you aware of this recording?" "No, Your Honor," she replied, looking somewhat flustered. "This is the first time I'm hearing about this evidence." "That's because," Sarah interjected politely, "according to the Juvenile Court Procedures Manual, Section 7.3, new evidence can be introduced during preliminary hearings if it directly pertains to establishing the defendant's innocence." Judge Thompson removed his glasses again, this time placing them on his desk as he rubbed his temples. In his 3 decades on the bench, he had never encountered anything quite like this. "Miss Mitchell," he said, "where exactly did you learn about Section 7.3 of the Juvenile Court Procedures Manual?" Sarah's eyes lit up slightly. "Last summer, I participated in a free online law course from Harvard University's ADX program. While I was technically too young to receive certification, they allowed me to audit the course after I wrote a detailed essay explaining my interest in juvenile law. The professor was quite supportive once he realized my commitment to learning." The courtroom erupted in murmurs. Diana Mitchell watched as people whispered and pointed at her daughter, but Sarah remained composed, her posture straight and her expression calm. "Order," Judge Thompson called, though his voice carried more amazement than authority. "Miss Mitchell, you mentioned your tablet records scientific observations. May I ask why you keep such detailed records?" "Of course, Your Honor," Sarah replied. "As stated in the case of Brown v. Board of Education, 1954, evidence must be both systematic and scientific to challenge existing presumptions. While that case dealt with segregation, the principle of maintaining detailed records to challenge unfair assumptions remains relevant today." The judge's eyes widened. Not only did this young girl understand contemporary legal procedures, but she could also connect them to landmark historical cases. "Furthermore," Sarah continued, "my records show that during the 3 months I've waited for this hearing, I've spent approximately 200 hours preparing my defense, including studying similar cases of wrongful accusations in juvenile courts." Mr. Harris, now fully alert, whispered to his colleague, "We're not defending her. She's teaching us." Judge Thompson looked at the evidence submission form on his desk, then back at Sarah. "Miss Mitchell, would you like to submit this recording as evidence?" "Yes, Your Honor," Sarah responded. "And if I may, I would like to cite one more case before we proceed with examining the recording." The judge nodded, now completely invested in what this remarkable young girl had to say. The truth or lie game had revealed far more than he had anticipated, and it was becoming clear that this case would be remembered in the Baltimore County Juvenile Court for years to come. "The case I'd like to cite," Sarah continued, "is Thompson v. State of Georgia, 2001, where it was established that electronic evidence must be authenticated and shown to be unaltered to be admissible in court." She reached into her folder and pulled out a sheet of paper. "I have here a certification from the Baltimore County Digital Forensics Lab confirming that this recording hasn't been modified." Judge Thompson accepted the certification, studying it carefully. The courtroom remained silent as he read, the only sound being the gentle hum of the air conditioning system. "Miss Mitchell," he said finally, "how did you manage to get the Digital Forensics Lab to examine your evidence?" Sarah's lips curved into a slight smile. "Every Tuesday and Thursday, I volunteer at the public library's computer literacy program for senior citizens. One of my regular students is Mrs. Eleanor Thompson, your wife, Your Honor." She mentioned that her son works at the forensics lab. For the first time that day, Judge Thompson looked genuinely surprised. You're the Sarah that Eleanor has been talking about. The one who taught her how to use video calling to talk to our grandchildren. Yes, Your Honor, Sarah replied. Mrs. Thompson was very kind to introduce me to her son, David. When I explained my situation, he agreed to verify the recording's authenticity during his lunch break. The prosecutor, Ms. Rodriguez, stood up. Your Honor, while this is all very impressive, I feel compelled to point out that the defendant seems to have orchestrated quite an elaborate defense strategy. Sarah turned to face Ms. Rodriguez. With respect, Counselor, in the case of Miller v. State of California, 1997, it was established that thorough preparation of one's defense cannot be used as evidence of guilt. In fact, it's a constitutional right protected by the Sixth Amendment. Mr. Harris, the public defender, couldn't suppress a chuckle. He had never been so thoroughly overshadowed by his own client. Judge Thompson held up his hand. Let's proceed with listening to this recording. He motioned to the court technician, who connected Sarah's tablet to the courtroom's audio system. The recording began to play. Clear voices filled the courtroom, exactly as Sarah had described. Tyler Wilson and Marcus Green could be heard complaining about their chemistry grades, followed by the unmistakable sounds of equipment being damaged. When the recording ended, Judge Thompson looked at the prosecutor. Ms. Rodriguez, do you have any questions about the authenticity of this evidence? No, Your Honor, she replied, shuffling through her papers. In fact, I just received a message from my office. Both Tyler Wilson and Marcus Green have confessed to the vandalism when confronted with the existence of this recording. Sarah nodded, unsurprised. As noted in Psychology Today's article on juvenile offender behavior, which I read at the library last month, most young offenders, when presented with clear evidence, tend to admit their actions rather than maintain false denials. Diana Mitchell wiped tears from her eyes, watching her daughter handle herself with such poise and knowledge. She remembered all the times she worried about Sarah spending too much time studying law instead of playing with friends her age. Now she understood that her daughter had been preparing for moments like this. Judge Thompson cleared his throat. Miss Mitchell, I have one final statement for our game of truth or lie. You're interested in pursuing a career in law. Sarah's face brightened. True, Your Honor. However, I'd like to correct a common assumption. I'm not interested in becoming a prosecutor or defense attorney. My goal is to become a juvenile court judge, focusing on reforming how the system treats young offenders, especially those from disadvantaged backgrounds. The judge leaned back in his chair, a look of admiration crossing his face. And why is that, Miss Mitchell? Because, Your Honor, while I've been fortunate enough to have the resources and support to defend myself effectively, many young people in this system don't have access to the same opportunities. As stated in the United Nations Convention on the Rights of the Child, every young person deserves fair and equal treatment under the law. The courtroom fell silent again, but this time it was a silence full of respect and wonder. Judge Thompson realized that what had started as a simple game of truth or lie had turned into something much more significant, a glimpse into the future of the legal system, personified in a remarkable 12-year-old girl. Judge Thompson set aside the case file and removed his glasses, looking directly at Sarah. Miss Mitchell, I believe we need to address something more significant than the vandalism case. Your knowledge of the law is extraordinary for someone of any age, let alone a 12-year-old. Sarah sat up even straighter, if that was possible. Thank you, Your Honor. However, as established in Wilson v. State Education Board, 2005, academic ability should be evaluated based on demonstrated skills rather than age-based expectations. The judge smiled. Are you aware that the Baltimore County Courts have a special mentorship program for gifted students interested in law? Before Sarah could respond, the courtroom doors opened, and a tall woman in a crisp black suit entered. The click of her heels echoed through the room as she walked toward the front. Sarah immediately recognized her as Justice Maria Hernandez, the first African-American woman to serve on the Maryland State Supreme Court. I apologize for interrupting, Henry, Justice Hernandez said to Judge Thompson, but when I heard about what was happening in your courtroom, I had to come see for myself. She turned to Sarah. Young lady, I've been reading the real-time transcript of these proceedings on my phone. Sarah stood up respectfully. Justice Hernandez, in your 2018 opinion on youth education rights, you wrote that potential knows no age limit. I've studied all of your published opinions on juvenile cases. Justice Hernandez raised an eyebrow, impressed. And what did you think of my dissenting opinion in the Matthews education funding case? Without hesitation, Sarah responded, while I understood your legal reasoning, I believe the majority opinion correctly applied the precedent set in Brown v. Board of Education regarding equal access to educational resources. However, your dissent raised valuable points about the practical implementation challenges that weren't adequately addressed in the majority decision. The courtroom fell silent again. Even Justice Hernandez seemed taken aback by the depth of analysis from someone so young. Your Honor, Ms. Rodriguez stood up. Given the new evidence and the confessions from the actual perpetrators, the state moves to dismiss all charges against Sarah Mitchell. Judge Thompson nodded. Motion granted. Miss Mitchell, you are hereby cleared of all charges. He paused, then continued, however, I'm not finished. Justice Hernandez, would you like to share why you're really here? Justice Hernandez smiled warmly at Sarah. Miss Mitchell, we've been developing a new Youth Justice Advisory Board, comprised of exceptional young people who can provide insight into how our legal system affects their generation. After hearing about your remarkable understanding of the law, I'd like to offer you a position as our youngest board member. Diana Mitchell gasped, reaching for her daughter's hand. Sarah remained composed, though her eyes sparkled with excitement. Thank you, Justice Hernandez, Sarah replied carefully. May I ask what precedent exists for youth participation in judicial advisory roles? Actually, Justice Hernandez responded, you would be helping us establish that precedent. Sometimes, Miss Mitchell, the law needs to evolve, and who better to help guide that evolution than someone who understands both the legal system and the youth perspective? Sarah thought for a moment, her analytical mind working through the implications. Would this position interfere with my current volunteer work at the library? I made a commitment to my senior citizens computer class. The adults in the room exchanged amazed looks at her sense of responsibility. Not at all, Justice Hernandez assured her. In fact, that kind of community service experience is exactly why we want your input. We need people who understand both the law and the human element. Judge Thompson added, and Sarah, I know Eleanor would be very disappointed if you stopped teaching her about video calls. For the first time that day, Sarah allowed herself a full smile. In that case, I accept the position, provided my mother approves. She turned to look at Diana, who was nodding through happy tears. Justice Hernandez extended her hand to Sarah. Welcome to the Maryland judicial system, Miss Mitchell. I have a feeling you're going to help us make some important changes. As Sarah shook the justice's hand, Judge Thompson couldn't help but think about how his simple game of truth or lie had led to this moment. Sometimes, he realized, the truth was more remarkable than any lie could ever be. 1 week after the hearing, Sarah sat in a large conference room at the Maryland State Courthouse. Around her sat distinguished judges, lawyers, and legal scholars, all gathered for the first meeting of the Youth Justice Advisory Board. Despite being surrounded by legal professionals with decades of experience, Sarah appeared completely at ease. Before we begin, Justice Hernandez announced to the room, I'd like to share something remarkable. Last night, I received Sarah's preliminary proposal for youth justice reform. Not only has she identified 23 specific areas where our juvenile system could be improved, but she's also provided relevant case law to support each recommendation. The room buzzed with impressed murmurs. Sarah pulled out her carefully organized binder, color-coded tabs marking different sections. I focused primarily on 3 main areas, she explained, her voice clear and confident. Access to legal education, reform of juvenile detention practices, and expansion of rehabilitation programs. Professor James Chen, a renowned legal scholar from Harvard Law School who had flown in specifically for this meeting, leaned forward with interest. Miss Mitchell, I understand you audited one of our online courses. Would you be interested in speaking to our students about your experience with the juvenile justice system? Sarah considered the offer carefully. While I appreciate the invitation, Professor Chen, I believe it would be more beneficial if I could speak to middle and high school students first. As noted in the Department of Education's 2023 report, Early exposure to legal education significantly reduces juvenile offending rates. Justice Hernandez smiled. And that's exactly why we needed her perspective, she told the room. While we discussed theoretical improvements, Sarah sees practical applications. Meanwhile, back at Roosevelt Middle School, things had changed dramatically. The principal, Dr. Roberts, had invited Sarah to establish a legal education club for students interested in learning about their rights and responsibilities under the law. The first meeting had drawn over 50 students, many inspired by Sarah's story. The law isn't just for adults, Sarah told her peers during the club's inaugural session. It's a tool for justice that anyone can learn to use effectively. She had even arranged for Judge Thompson to be a guest speaker at their next meeting. Tyler Wilson and Marcus Green, the two boys who had vandalized the science lab, had been sentenced to community service rather than juvenile detention, partly due to Sarah's recommendation. She had cited studies showing the effectiveness of restorative justice programs over punitive measures for first-time offenders. Your Honor, she had written in her recommendation to Judge Thompson, studies show that 87% of juveniles who participate in community service programs show improved behavior, compared to only 32% of those who face traditional punishment. Sarah's mother, Diana, watched these developments with pride and amazement. One evening, as Sarah sat at their kitchen table working on her latest proposal, Diana asked her daughter a question that had been on her mind. "Sarah, honey, how did you stay so calm that day in court? Weren't you scared?" Sarah looked up from her papers. "Mom, remember when you taught me to play chess? You said the key isn't just knowing how the pieces move, but understanding why they move that way. That's how I see the law. It's not just about knowing cases and statutes. It's about understanding why they exist and how they protect people." That weekend, Sarah received an unexpected visit from Justice Hernandez at her library computer class. The justice sat quietly in the back, watching as Sarah patiently taught elderly community members how to navigate the internet and use video chat applications. "Miss Mitchell," Justice Hernandez said after the class, "I've seen seasoned lawyers with less patience and teaching skill than you just demonstrated." Sarah responded thoughtfully, "Justice Hernandez, in your 2019 speech on community law, you said that legal knowledge is only valuable when it serves the community. I'm just trying to put that principle into practice." As Sarah gathered her teaching materials, Mrs. Eleanor Thompson, the judge's wife, approached her with a warm hug. "You know, dear," she said, "Henry hasn't stopped talking about you. He says you've reminded him why he became a judge in the first place." Sarah smiled, remembering how a simple game of truth or a lie had opened so many doors. But she knew this was just the beginning of her journey to make the legal system more accessible and fair for everyone, regardless of their age or background. 3 months after Sarah's memorable court appearance, she stood at a podium in the Maryland State Capitol building. The governor had convened a special session on juvenile justice reform, and Sarah was invited to be the keynote speaker. The chamber was packed with legislators, judges, and education officials. "The juvenile justice system," Sarah began, her voice steady and clear, "shouldn't just be about punishment. It should be about understanding and opportunity." She paused, looking around the room. "When I was accused of vandalism, I had the tools to defend myself. But what about the thousands of young people who don't?" In the audience, Judge Thompson nodded approvingly. Beside him, Justice Hernandez was taking notes. Sarah's recommendations had already led to significant changes in how the Baltimore County courts handled juvenile cases. "Last week," Sarah continued, "I visited the Baltimore Juvenile Detention Center. I spoke with young people my age who had never heard of the legal precedents that could have helped their cases. They didn't know their rights. They didn't have access to the resources I found at my local library." Diana Mitchell watched from the gallery as her daughter commanded the attention of some of the most powerful people in Maryland. She remembered the night Sarah had first told her about wanting to visit the detention center. "Mom," Sarah had said, "if I could learn the law from library books, why couldn't other kids? The problem isn't that they can't understand it, it's that nobody's making it accessible to them." At the podium, Sarah held up a tablet. "This contains a proposal for a new program called Law for All. It's a mobile app that explains legal rights and procedures in simple language that young people can understand. The app includes video tutorials, case studies, and direct links to legal aid resources. The governor leaned forward with interest. Several legislators began whispering among themselves. The program has already been tested at 5 middle schools in Baltimore, Sarah explained. In just 2 months, we've seen a 40% increase in students' understanding of their legal rights and responsibilities. More importantly, there's been a 25% decrease in disciplinary incidents at these schools. Justice Hernandez stood up. Miss Mitchell, how do you propose to fund this program statewide? Sarah had anticipated this question. The cost of implementing this program in all Maryland schools would be less than what we currently spend on juvenile detention for nonviolent offenders in a single month. As demonstrated in the case of Edwards versus State Education Board, preventive education programs are not just more effective, they're more economical. The room erupted in applause. Sarah waited patiently for it to quiet down before continuing. But this isn't just about an app or a program. It's about changing how we view young people in the legal system. When I stood in Judge Thompson's courtroom playing Truth or Lie, I wasn't just defending myself. I was demonstrating that young people can understand and engage with the law meaningfully. From his seat, Judge Thompson smiled, remembering how his simple game had revealed such extraordinary potential. My mother always tells her English students that knowledge is power, Sarah said, glancing at Diana. But knowledge only becomes power when it's accessible. Every young person deserves the chance to understand their rights and responsibilities under the law. As Sarah concluded her speech, the governor approached the podium. Miss Mitchell, your proposal has my full support. Furthermore, I'd like to establish a youth legal education fund, with you as its first director. Sarah blinked in surprise. This wasn't part of the plan, but her mind quickly processed the opportunity. Thank you, Governor. However, I believe this position should be shared with a rotating panel of young people from diverse backgrounds. As stated in the case of Martinez versus Arizona Department of Education, representation matters in educational leadership. The governor looked impressed. Consider it done. Later that evening, as Sarah and her mother drove home, Diana asked, Are you sure you're not taking on too much, honey? You're still 12. Sarah looked out the window thoughtfully. Mom, age is just a number. Justice Hernandez says what matters is what you do with the opportunities you're given. She turned to her mother with a smile. Besides, I've already drafted a schedule that allows time for homework, a library program, and even some basketball. Diana laughed. Of course, her daughter had already planned everything out. As they drove through Baltimore, Sarah spotted the library where her journey had begun. She made a mental note to thank Ms. Jenkins, the librarian who had first shown her where to find the law books. Sometimes she thought the biggest changes start with the smallest moments. 1 year after Sarah Mitchell's first appearance in Judge Thompson's courtroom, the Baltimore County Courthouse looked very different. The Juvenile Division now had a dedicated legal education center where young people could access resources similar to those Sarah had found at her library. The center was busy today, as students from local schools attended a special ceremony. Sarah stood at the front of the room, watching as Judge Thompson addressed the gathering. She was now 13, and though she'd grown a little taller, she maintained the same composed demeanor that had impressed the court a year ago. When I played Truth or Lie with Sarah Mitchell, Judge Thompson said to the assembled crowd, I thought I was being clever. Instead, she taught all of us a valuable lesson about assumptions and opportunities. The audience included many familiar faces: Justice Hernandez, Ms. Jenkins the librarian, Professor Chen from Harvard, and dozens of young people who had benefited from the Law for All program. In the front row, Diana Mitchell wiped proud tears from her eyes. Today, Judge Thompson continued, we're celebrating not just the success of the Youth Legal Education Program, but also its expansion to 50 other cities across the country. And it all started because one 12-year-old girl decided to spend her afternoons reading law books. Sarah stepped up to the podium. Over the past year, she had given many speeches, but this one felt special. When I stood in this courthouse a year ago, she began, I was accused of vandalism. Today, we've helped over 5,000 young people understand their rights and responsibilities under the law. She gestured to a group of teenagers sitting together. Tyler and Marcus, who once vandalized our school's science lab, are now peer educators in our program. They teach other young people about making better choices and understanding consequences. Tyler and Marcus smiled sheepishly. Their community service had turned into a genuine passion for helping others avoid their mistakes. But our work isn't finished, Sarah continued. Next month, we're launching a national online platform that will make legal education accessible to young people everywhere. And thanks to Mrs. Eleanor Thompson's computer class at the library, we've made sure even our senior citizens can access and understand it. The audience laughed as Eleanor Thompson waved from her seat next to her husband, the judge. The law isn't just for lawyers and judges, Sarah said. It's for everyone. Every person, regardless of age, background, or circumstances, deserves to understand their rights and have the tools to protect them. Justice Hernandez stood up. Sarah has shown us that age is not a barrier to understanding justice. Her work has influenced judicial policy across the country. Last week, the Supreme Court cited the success of her program in a landmark decision about juvenile rights. Sarah's mother couldn't help but remember all the times she worried about her daughter spending too much time studying law instead of being a normal kid. Now she understood that Sarah had never wanted to be normal, she had wanted to make a difference. As the ceremony concluded, Sarah had one more surprise. Today, we're announcing the creation of the Mitchell Scholarship, she said. This fund will support young people who want to study law and justice, especially those from underserved communities, because everyone deserves the chance I had. The room erupted in applause. As people began to mingle afterward, Judge Thompson approached Sarah. You know, he said with a smile, I still have that recording from our Truth or Lie game. I play it for every new juvenile court judge in training. Sarah smiled back. Sometimes the truth is more powerful than any game, Your Honor. As she looked around the room, Sarah saw the future she had helped create. Young people discussing law with judges and lawyers, elderly community members learning about their rights on tablets, and former juvenile offenders becoming mentors to others. Diana hugged her daughter. Are you ready to go home, sweetheart? You have that science test tomorrow. Sarah nodded. Despite all her accomplishments, she was still a student, still learning and growing. But she had proved that age was no barrier to understanding justice or making change. As they left the courthouse, Sarah paused to look at the building where her journey had begun. The sign above the door now read, Baltimore County Courthouse, where justice knows no age. The game of truth or lie had ended long ago, but its impact continued to ripple through the justice system, changing lives and opening doors for generations to come. And it all started because one young girl decided to tell the truth, not just about herself, but about what justice could really mean.